Доброе утро, дорогие друзья.
Good morning, dear friends. Good morning, colleagues, citizens of the Russian Federation as other foreign nationals. Today, we're very pleased that despite having a Friday morning and despite yesterday's almost small hours of the night banquet, we successfully made it here to discuss a challenging and interesting topic for the legal profession, for the legal community and business, the issue of affiliation. We also would like to discuss the concepts that are quite commonly used in the Anglo-Saxon legal system, American, European and German in particular, the so-called corporate veil piercing. With regard to affiliation as such, because one of the reasons for the court to rule the necessity of piercing of the corporate veil, there should be evidence and as proof of the affiliation of the legal entity for the piercing of the corporate veil. So the affiliation issue is of great importance here. Affiliation issue exists in Russia as well, but our roundtable discussion will look at international experience first and foremost, and I would like in my brief introduction to say a few words about affiliation status and to say what the challenges are, and then we'll move on to international panelists to see how other legal systems resolve this issue, because in Germany the institution of affiliation has been around for a long time and is commonly used in different types of corporate relationships, and Henry Müller, representative Mr. Ulrich, will tell about it in detail in his turn, and I'll introduce all the speakers as they go. So, the principle of affiliation in the Russian law. I think that the affiliation problem is because there is no such clear-cut definition of affiliation. Different laws view it differently. Corporate and antitrust laws and competition laws and the relevant articles of the laws on limited liabilities companies and shareholder companies. So the group of entities is also defined, especially if there is a need to notice the anti-monopoly committee. The issue arises who to disclose, and of course you would not wish to disclose everyone, as you understand. Some pressing the same buttons, but it doesn't move, so it takes 3 times. So corporate law, the goal is to identify just the interest in the transaction. For example, participation in the authorized capital, over 20%, participation in the governing bodies, being a relative, and affiliation with an interested person. So a criteria to determine affiliated persons. So antitrust law has the goal to determine economic concentration. So it's overwhelming participation in the authorizing capital, over 50%, an agreement that determines the conditions of the activity, and the overwhelming participation in the board of directors, or just being a relative a person in a group of persons. So the law enforcement problem is that the law sets out the major legal criteria, just control through the participation in the authorized capital or governing bodies, or being member of one and the same group of persons. Lack of factual criteria, so the possibility of influence the decisions without taking part in the capital or governing bodies, like big creditors, can affect the decision. So affiliation can be proved without formal features, but with the facts of direct control being proved. there is no exceptions from the legal criteria, so it's formally affiliated through the participation of over 20% in the authorized capital, and one person has no influence on the activity of other peoples, and so the law lacks the criteria of affiliated physical persons, for example, individual entrepreneur. So just entrepreneurs, individual entrepreneurs are not included into the legal regulation of the affiliation institution, thus entailing various views on the issues and practice of law enforcement. So this was briefly the major set of challenges in the Russian Federation. So our lawmakers seek to resolve it in the civil code. And such an attempt was made, if you remember, in the first version, where the definition of affiliation was referred to the discretion of the courts, which was very negatively responded to in the legal profession, in the legal community and business. So, and then this article was scratched out of the law because it was too generalistic in its wording. So as of today, the situation is as I described it. So briefly about the Russian experience. So very briefly going to introduce our first speaker and turn the floor over to Michael Polonsky. Michael is the partner of the BLP company in London, and Michael will speak about the corporate veil piercing and related issues in English law. Michael specializes in corporate law, as far as I know. Am I right? Thank you, Michael. We would like to have it a more interactive format, so I would like to ask the presenters to be brief, and I would invite comments or questions from the floor as soon as you have them. Please just introduce yourself and briefly formulate your questions. So we're going to begin. Mike, the floor is yours.
I'm going to cover very, very briefly the English law idea of the corporate veil and the circumstances in which you can look behind that veil. I am going to do it partly with slides because the facts of the cases that I'm going to describe to you are a little difficult to appreciate without visual aids. And because I'm trying to speak within a limited period of time, there are some slides that I will just jump through. But the corporate veil is essentially the separation in English law of the rights and obligations of the company and the rights and obligations of the shareholders who own it. And the best illustration, the leading case, is a case of Salomon and Salomon. Mr. Salomon was a leather trader who decided his business was successful, and he decided to transfer it to a limited liability company where he was the main shareholder. Unfortunately, after transferring the business to the company, the business did very badly. It incurred a substantial number of debts and went into liquidation. And the question was, could the creditors of the company, when there were insufficient assets in the company to pay them, could they pierce the veil of incorporation and hold Mr. Salomon personally liable? And the House of Lords held no, there was no claim that the creditors could make as against him, and he had no obligations towards them. That separation of shareholder and company is what is called the corporate veil, a curtain that separates the company and its shareholders. And it was one of the more important developments in the growth of capital economies in the 19th century, because it enabled an investor to invest in a business, but limiting his liability to the amount that he had spent in purchasing share capital. Now, there are exceptions to the corporate bail. There are circumstances in which the shareholder can be held liable. I'm not going to talk about Adams and Cape, but I'm going to go to the main exception, and that is where the court considers that the use of the company has been to create a sham or a facade, effectively the use of the company as a device in order to evade liabilities. And the case I want to illustrate this with is Guildford Motor Company Limited against Horn. As those of you who are not English lawyers may know, English law develops the principles that it applies through a succession of decisions of courts which in turn build on previous decisions or else distinguish or differ from previous decisions. Now, in this case, Guildford Motor Company employed Mr. Horn as its managing director. They sold motor cars, and they took from him a promise that when he left employment with them, he would not effectively compete with them. So what he did was he incorporated a company of his own, he left their employment, and the company competed and tried to get business from former customers of Guildford Motor Company. Guildford tried to stop this, but Mr. Horn said that he was not competing, it was the company that was competing, and the company said it had given no promise not to compete. The court said, we will pierce the veil in this situation, we will look behind the form and go to the reality and hold both Mr. Horn subject to an injunction to prevent him from competing, but also the company. And the explanation for this was that these were cases where the company was being used, the various expressions that the judges have used over time, a device, a stratagem, a mask, a sham. They're really instances where the court pierced the veil. I'm going to jump now to recent developments because there was an attempt in recent years, since 2011, to hold the controlling shareholder of a company bound as a party to an agreement that the company itself had entered into. Now, I should explain that when the English court considers whether it has jurisdiction to entertain proceedings, one of the basic grounds is that the parties have agreed by contract to submit their disputes to the jurisdiction of the English court. And Gramsci and the cases that follow are all cases where there was an agreement to submit disputes to the jurisdiction of the English court, but the question was whether the controller of the company that was a party to the contract could be treated as a co-contracting party. Gramsci was a case where there was a Latvian shipping company which chartered out vessels, and it chartered them using a range of, I can't read how many it is from here, but a large number of, thank you, I need binoculars, a large number of subsidiary companies. Now, it had prospective customers who were charterers of its vessels, and there was a clear corporate opportunity for it to make money by chartering vessels to what I've called the real charterers. However, the charter group within the Latvian shipping company was controlled by a number of individuals who decided that they would like to make the profits that would otherwise be made by the Latvian company. And what they did was they set up a number of offshore companies which they controlled, and they ensured that the 39 companies that owned the ships would actually enter into charters with them. Those charters contained an English jurisdiction clause, But it was they, through the device of these offshore companies, who then entered into sub-charter parties with the real charterers. And the question was, there is a claim that the English courts will allow, that English law allows, between those shipping companies, of which Gramsci was one, and these wrongdoers, but it's a claim in tort or delict, and there was a dispute as to whether the English court could have jurisdiction. If the controllers, Stepanovs and his colleagues, were indeed parties to these agreements, they would have contracted to submit disputes to the English courts. And in this case, and in a following case, a judge at first instance, Mr. Justice Burton, held that there was no reason why, if a company was being used as a puppet, why the puppet master, the person pulling the strings of the puppet, should not also be held contractually liable to the contracts which the company entered into. The same situation arose in the case of Alliance Bank, that's the English Alliance Bank, against Aquanta, and it was the same judge who reached the same decision. The matter then came before the Supreme Court of the United Kingdom in February or March of this year. What they decided was the same situation where VTB Capital, an English bank, had entered into facility agreements with Rusagroprom, which I'll call RAP, a Russian company, and under the agreements, VTB loaned $225 million to RAP to enable it to buy 6 Russian dairy companies from a BVI company, Nutritech. What then happened was RAP defaulted on its repayments, and VTB sued Nutritech, alleging that there had been misrepresentations made which caused it to make the loans. It also sued Mr. Malofev and one of his other companies, Markup, a BVI company. The allegation was that he was the controller not only of Nutritech but also of RAP. Now, again, English law would have given a remedy against him if he had been liable for the misrepresentations. But what happened was that VTB Capital wanted to hold, in order to uphold the jurisdiction of the English court, wanted to hold him as a party, treat him as a party to those facility agreements between VTB and RAP. And the English court, the highest court in England, decided that that was a step too far. You could not pierce the corporate veil so as to hold one party that was not intended to be a party to a contract to be a party to that contract simply because of his control. Now, I have to say in conclusion that this was an interlocutory application. It was a decision not on the merits of the case, but on the hearing of an application to amend the claim. And the majority judgments made it clear that this was not an appropriate case to investigate and decide on the circumstances in which the English court will allow the corporate veil to be pierced. But they did so in circumstances where they suggested that there might be no circumstances in which the corporate veil could be pierced. And the minority judge himself said that he reserved for a later case the question whether Gramsci had been correctly decided. So what I've tried to show to you is what English law considers as the difference between the company and its shareholders, the circumstances in which that corporate veil could be pierced, circumstances in which it cannot be pierced, and it's left, I'm afraid, with a question mark: where will things go next? Thank you very much.
Thank you, Michael. That was wonderful presentation. По меньшей мере, на мой взгляд.
At least this is what I think. So the situation, even in the English law sphere, is far from being easy and simple. and that system dominates not only the common law system, nor corporate law or arbitration. Still, decisions being taken would be very different. While cases may seem similar, both parties try to prove control, involving the ultimate beneficiary liable for debts of strangely affiliated companies. In the Gromsky case, control was more obvious than in the Nutritech case. However, still, courts made different decisions on seemingly similar cases. So if you want to avoid covenants, and you create a subsidiary that started to do that, which for Russia is not a big surprise or any big news. So as we are going to discuss that with Russian experts, Ms. Makovskaya for one, of course I would love to hear what she thinks about similar things going on in Russia, because in Russia we wouldn't need to have any decision made, we would just need to sit down and have a professional chat. Now let me give the floor to Sarah Hutchinson. She is going to talk about the linkage between the concept of piercing the corporate veil and the concept of affiliation, to what extent these two things overlap and should be interpreted. Sarah is a solicitor since 1999. She's been expert in real property in London and Manchester, and then she started to teach at the University of Law. Currently she is at the University of Law, Director for Business Development. Almost precisely. Sarah, you have the floor, please.
Michael has already produced a very interesting review of the case law, so just very quickly Oh, it's okay, I've got this one, thank you. That's very kind. And I won't go over the cases again. I just wanted to quickly sum up the case. I think it's interesting that the Supreme Court has recently reached a decision on VTB capital. I hear that there is another Supreme Court case on piercing the corporate veil, which is due to be heard this summer. In terms of the very limited conditions where the court has been willing to affix liability beyond the company, I think you could sum up by simply saying that the interests of justice are not enough. So in other words, the English courts are not prepared to affix liability within a group of companies simply because there has been some form of wrongdoing. It's very clear that there are very limited circumstances where the English courts will, in a corporate structure, go beyond that. Particularly, they would be looking for circumstances where the corporate structure itself has been created or devised to avoid liability. So the wrongdoing has to be directly linked to the creation of the corporate structure, such that the corporate structure is used to conceal the liability. The courts will also only go so far as is necessary to provide a remedy for a particular wrongdoing. So there are very, very restricted circumstances where the courts will pierce the corporate veil, as it's called, in order to affix liability. I think it's interesting that we're all very excited about the VTB case in Nutritech in English courts. But actually, when I'm telling my students where to look for a summary, I would not start with VTB. I think it's very it's a fairly peripheral issue to the main issue within VTB capital. Normally, I advise the students to go back to the decision, a 2008 decision of Hashim and Shayev, which is a very thorough review of the circumstances where the corporate veil has been pierced. And there was a very helpful summary provided in that case. In that case, the Justice Munby set down the circumstances in which they will pierce the veil. And you can see there that there is wrongdoing, there is control by the wrongdoing, there is a misuse of the company structure itself to conceal that wrongdoing, and of course, ultimately, motive is highly relevant. And that is in itself quite a tricky concept in English courts to establish, and it is why we would say that the circumstances, as a matter of corporate law, why the circumstances in which the veil would be pierced are very limited. Andre has asked me to try to draw the links between the concept of affiliation and the concepts in English law. So I'm chosen to steal a quote from one of our famous poets, John Donne. No man is an island entire of itself. And therefore what I'm trying to say here is that although we hold sacrosanct limited liability within the English courts, in fact there are concepts where there are many circumstances in English law where in fact the court or statute has looked beyond the pure structure of the company itself. So let's try and find some examples of where the English courts have gone beyond the corporate structure. And therefore one could draw analogies with the Russian concept of affiliation. The first example would be commercial fraud. So in commercial fraud, the term commercial fraud is a very broad concept, but most particularly one would look to affix liability beyond the immediate company where there has been in a tort of deceit or perhaps a breach of trust, a fiduciary duty that has gone beyond the initial company. And in those circumstances where one could establish a commercial fraud, and it is a very broad concept, then in those circumstances the court has been willing to attach liability beyond the immediate company. So, for example, they would hold a director of that company liable personally for the wrongdoing, or they would perhaps look to a group of associated companies to establish liability. There are numerous examples of where statute, in effect, goes beyond the company to affix liability. And I think these are statutory exceptions could be used as an analogy for the Russian concept of affiliation. So an example I have put forward here is that under Section 213 of the Insolvency Act, where a group of directors or controlling people have continued to trade knowing that the company cannot discharge its debts, then the individual directors could become liable for the debts of that company, and that is the concept of fraudulent trading. And therefore, one has an example here of where the statute itself is imposing liability beyond the corporate structure, the immediate corporate structure. Beyond statutory exceptions, there is also the concept in English law of agency. There is a very interesting case, Adams and Cape Industry, 1990, which Michael referred to, where in that case, in effect, the parent company was actually was operating its business through the medium or the agency of a subsidiary company. And in those cases, the court was prepared to affix liability to the parent company because the subsidiary company itself was merely an agent or merely an acting party on behalf of the parent company. It is a very limited set of circumstances. I think in those cases I wouldn't want to overplay the agency case. There have been examples used, the term which is often referred to as a single economic unit, where the companies are acting as one unit or one organisation and the structure is merely a vehicle through which the parent is doing business. Very limited circumstances in there. Where I think perhaps developing more interesting concepts it appears to be in the public policy cases. So there is a 2002 case, Chandler and Cape, where the Court of Appeal held that the parent company owed a direct duty of care to the employee of a subsidiary company, where that subsidiary, in fact what had happened was that the employee had contracted asbestos due to exposure to asbestos dust. I'm not sure this is an example of piercing of the corporate veil. There have been many commentators who have argued that it is not a piercing case because, in fact, what was happening here was that the parent company had assumed responsibility for health and safety. Basically, the parent company's health and safety agent was actually advising the subsidiary company on matters relating to health and safety, and the courts therefore held that the parent company had stepped into the shoes of the subsidiary and assumed that liability, so had taken over the decision-making in relation to health and safety. It does appear to be a very a public policy case, I think where the courts have exercised its discretion, saying, well, as a matter of public policy, where asbestos, which is a very serious case, the parent should not escape liability in that case. And then, of course, beyond the English courts and beyond statutory exceptions, the EU competition law has also attached liability on a parent where there is evidence that that subsidiary is acting under control. So an example I've given there, worldwide tobacco case. I think what's interesting about the EU competition law is that clearly this is an example where the Commission has it has an incentive to look beyond the immediate corporate structure, because under the cartel fines will attach or will be calculated by reference to the company that has the deepest pockets. So where you have a company that has where the subsidiary company is perhaps quite small, the Commission will look for who is the richest company within the group, and then they will calculate their fines according to that measure. And therefore I can see in that case competition law is deliberately trying to look behind the corporate veil because it wants to find the richest company in order to be able to calculate the cartel fines. So that's quite an interesting example there of where EU competition law has also affixed liability beyond the immediate company. In conclusion, there is a famous English academic I was reflecting upon whether the piercing of the corporate veil is a modern concept in English law. And actually, as far back as 1975, Schmidhoff famously said that concepts of company law must give way to the realities of life where there are economic and ethical considerations which don't justify the court separate limited liability. And I think that's quite interesting because there are so many cases going through our Supreme Court at the moment that there is a perception that piercing the corporate veil is new. And in fact, there are examples that go back a long way that suggest that the English courts will pierce the corporate veil where there is relevant ethical or social or public policy issues at stake. Or not. Thank you.
Thanks a lot, Sarah. Dear colleagues, I think we have shaped in our minds a conceptual understanding of what the piercing of the corporate veil is in the common law country like the UK. And an interesting question for us to discuss a little bit later is there a closed list of circumstances where piercing is possible? But before we touch upon that, let me give the floor to Ulrich Blech, Dr. Ulrich Blech, partner for Hengeler Müller in Germany. He is the Bonn University graduate and the School of Law at Chicago in 1999, when Ulrich was the PM, the parliament member, right? And right then he got the counselor status and he started to work for Hengeler Müller, and starting from 1995 he's been partner. From 2002 and 2003 he was based in London, so he's well versed in both legal systems, because I think whatever you say, the continental law system and the German system included is somewhat closer to what we have in Russia, or we are close to them. And Ulrich is ready to tell us about the concept of affiliation in the German law, the way it functions, the way it formulated, and the way it applies. This should be very interesting as part of our discussion, and of course later we will hear Ms. Makovskaya about the vision of the judiciary in Russia. Thank you. Ulrich, you have the floor now, please.
So, thank you very much. Being German, of course, we started, when discussing affiliated enterprises, we started with a systematic approach, tried to find a systematic solution for everything, but ended up with case law as well to a large extent. So let's see how this works. To explain the concept of the issue per itself, the general issue is we have one very strong party who controls a number of entities which have minority shareholders and which have, each of them has creditors. Evidently, the strong party, the shareholder, in most cases, wants to direct the companies as a group, wants to allocate business opportunities into such entity which he considers fit for that purpose. Evidently, this is a problem as well for minority shareholders as creditors. Minority shareholders will end up possibly with a company which has all the bad business in it, whereas others have all the good business, and likewise, the creditors might have a good company owing money or might have a bad company owing money to them. Now, how is this problem solved? In Germany, we have a rather differentiated system. Statutory systems, certain laws, certain structures under the law, which provides for protection of those minority shareholders and creditors, and we have, to a large extent, case law as well. All these systems have one thing in common. We are not systematically piercing the corporate veil, but we are creating compensation claims by those subsidiaries against the controlling entity. This happens in different structures, depending on the kind of company. Let's start with the stock corporation, and then we will address the limited liability company. To fully understand the concept with regard to stock corporations, I would need to briefly explain to you how stock corporations in Germany work. In Germany, we have a stock corporation with a shareholder assembly or shareholder meeting, which appoints the supervisory board and which then in return appoints the management board. The management board is not subject to any instructions. They are very independent. It's pretty difficult under certain circumstances to remove them before the end of their term. So they are acting independently. In theory, a shareholder, a majority shareholder, once he has appointed a supervisory board and the supervisory board has appointed the management, if the management is very strong, he has problems controlling it. So he has a certain interest of finding a mean how to control it, and that's where the so-called control agreement comes in. This was introduced in the 60s, basically. It's a legal concept which provides that the controlling entity and the controlled entity enter into an agreement under which the controlled entity submits its management, its actions, to the instructions of the controlling entity. By that agreement, the majority shareholder can easily instruct the company to do whatever he wants. He doesn't have to take care, within certain limits, on the interests of the minority shareholders there or the creditors. But there's a price to be paid for that. Now, I'm always slow with that. The first price to be paid is the controlling entity, during the term of the agreement, has to compensate the annual loss the controlled entity incurs. So if the controlled entity has a loss in one of the years during the term of such agreement, the controlling shareholder has to compensate that loss. It doesn't depend on whether this loss results from his instructions or other reasons. He simply has to compensate it. If he wants to terminate the agreement, You might think so, it's a wise idea because the company is making lots of losses. He can't evade this obligation that easily because he has to put up some collateral for the creditors for the period until he terminates. So it's pretty protected. Minority shareholders, how are they protected? They are protected twofold. First of all, once the company enters into such a control agreement with the consent of the majority shareholder, they basically have a put right. At a defined price, they can offer or they can tender their shares to the controlling shareholder. This price is defined and controlled by a special court proceeding, which may take years, actually. It's a very cumbersome process, but it's a pretty fair process at the end of the day. In parallel, he can decide to stay in the company, but in such case, he gets something like a guaranteed dividend. Basically, again, it's calculated on the basis of an evaluation of the company and reviewed by a special court proceeding. And finally, liability of the management. The management of the controlling entity, of course, is also responsible to properly conduct the business of the controlled entity. So we have a threefold protection on that system. The underlying doctrine, as I mentioned before, is always the same. You can influence the company, you can control it. There's no direct liability of the controlling entity vis-à-vis creditors or minority shareholders. However, there's a claim by the controlled entity vis-à-vis the controlling entity. And such controlled entity, of course, can be enforced and must be enforced. Even shareholders can enforce it against the controlling entity. I skip all the details how we enter into this agreement and now turn to the more interesting concept of de facto control. De facto control is a situation where the controlling shareholder doesn't enter into this agreement. Where we have somebody who is able to control the company, he may instruct the company provided that he compensates any disadvantage which results in such company from his instructions. So if he instructs the company or makes the company buy a bad other company, and as a result the company is incurring losses, he has to compensate such specific losses. Who is obliged under this concept? First of all, shareholders who hold the majority of shares, either by capital or votes. In such case, if they hold the majority, it's assumed by law that they are responsible. It can be that they have joint control with other shareholders, that they are jointly voting, that they have an agreement, shareholder agreement. De facto control may also result from simply having the majority in shareholder meetings. In public listed companies, it's quite often that only 60% of the shareholders show up. There you may have with 30, 31% the majority and you are able to control the company. In such cases, you are under this obligation as well. What's not happening, however, is you are not an affiliated enterprise and not a controlling enterprise if you just have a blocking position. If you have many small shareholders and you only have 10%, you are the biggest one, you are able to block things, but you have no positive control, you only have negative control. That's not sufficient to trigger this liability. Or being a supplier or creditor doesn't trigger this liability. As mentioned before, we have, as a result, the liability of the controlling entity for the actions, for the specific disadvantages it has caused by its actions. To ensure such concept, there's a reporting duty. The management of the controlled entity annually has to produce a report under which it says, I've got those instructions and they resulted in those disadvantages for us and they were compensated in that way. This report can be or is audited, reviewed by the supervisory board, and audited by the company's auditor. If the company fails to do that, minority shareholders can claim that such report is produced and can force the company to do so. Limitation, of course, of this concept is it's always looking at a single action which caused the detriment. Simply by being part of a group does not trigger this liability. Unfortunately, in most cases, we do not have clear-cut negative instructions by a company. It somehow happens. They are doing it, the management is doing it without receiving instructions. So this concept is not really watertight. Well, let's move to the more practical issue of the GmbH, the limited liability company. That's the format you will find with most mid-sized but privately held companies. Again, a brief outlay on the concept. In the GmbH, we have a shareholder meeting which appoints the managing director. The shareholder meeting can at any time revoke the appointment of the managing director. The shareholder meeting can give instructions to the managing directors. Hence, the company is very much under control of the shareholders meeting. Hence, this kind of company is much more at risk, so to say, that the controlling shareholder does what he likes rather than what's good for the company and what's good for the other shareholders. I'm speeding up a little bit. Just as a general remark, generally we have these control agreements for these kind of companies as well. You may ask why, because after all, the shareholder can instruct the company even without having this control agreement. That's true. But under German tax law, in order to get tax grouping, you need such an agreement, and that's a strong incentive to have these agreements in place. But what's much more relevant is the fact when you have de facto control. Unfortunately, the de facto control concept, which we have seen for the stock corporations, do not apply to the limited liability companies. And there case law comes in. And then we are very close to Sarah, where with her concept, we have some general concepts on you must not withdraw the registered capital, the managing director must not give out money to a shareholder, which ultimately is missing and results in an insolvency. And finally, the controlling shareholder must not act fraudulently, violate his fiduciary duties. The tests for this are pretty high. It's very close to fraudulent actions. It's very close to the intention to do something bad. It doesn't happen by chance. If these cases happen, and the courts have moved forth and back on that, you look at these cases and you know something is wrong. In the normal, properly organized company, this is never a problem. If you have cases where the controlling shareholder really moves assets from one company to the other, and to the detriment of creditors, without any kind of economic purpose other than his own benefit, you might have these problems. But these are extreme cases. Bad cases produce these kind of decisions. And that's an ongoing development. We will see. It's based on tort law now, and it's probably, as I said, close to the tests we have seen in English law. Thank you.
Well, Ulrich, thank you very much. I think that was fantastic.
Well, actually, I prefer a German idea to the English one. And I did like this idea about the control agreement, because on the one hand, it allows to settle some regulatory frameworks, and on the other hand, the shareholders entering into this agreement understand from the very beginning that they will have to be liable for the controlled company. We in Russia have neither of these two options, neither this control agreement nor consolidation agreement, and I believe that our legislation and our legislators have to work on these ideas. Because I heard several times that the English law doesn't fit and doesn't match our structure, but it seems that it fits perfectly well the German law, and they have obtained a very good combination between continental, or let's call it German law, and British law. And now I'd like to invite finally Alexandra Makovskova, who is the judge of the High Court of Arbitration, and I would like to ask her opinion about the topics of our discussion. So I would like to ask her the following questions. Can we hold a person liable for the contract signed by this person and for the breach made by the company he manages? And so what's your attitude to this control agreement that was presented by our German partner and to the topic of affiliation as a whole? I would like to apologize in advance. I don't have much time to stay here with you because I have to leave to the funerals of Mr. Alexeyev, so I have just a few minutes to give you my ideas about Russian legislation and affiliation and liability topics. So the notion of affiliated person in Russian legislation. I have been dealing with this topic for quite a long time, and neither our legislators nor other stakeholders ever objected to the rewording, revising of affiliated persons notion within our corporate law. But we have always faced one principal barrier. So, where to put this definition? Where to put this notion? When we revised our civil code, the group that was working in the International Legal Center asked to introduce this definition into the civil code, but it was rather formal. And one of the formal objections was that none of continental legislations have this definition in the civil laws. But I always saw this second obstacle, why not putting this definition into our civil legislation, because affiliated persons, together with the second notion, the piecing of corporate veil, is just a tool. It's not a purpose per se. But the instrument, the tool, should be included into the legal act that is appropriate and that will use this tool. So what happened in the long run, in the result? We included the notion affiliated persons, but that's just a single case. There is no continuation. So it's an insertion. There is no place for this definition. It's kind of an alien body within the civil code. The second issue that was discussed today is how to define the affiliated person. And we have not yet found the proper way. There are actually two options: either a very strict formalized definition, and in this case there will be a lot of bypasses. There will always be the cases that will be not covered by this formal definition, or give the freedom to the interpretation of the courts, to the, let's say, case investigations. And here we had a collision of interests, or a demonstration of mistrust towards our courts. It's not the first panel that I attend, and I heard several times that we need to borrow some institutions from Anglo-Saxon law, but such borrowings imply that these institutions will be adopted. They will be settled on our local land through the court practices. I'm afraid that you may come against the case when a strict formalized definition will not allow you to use your rights. You will be sorry. Well, for the time being, there is an idea not to define anything at all. So I think, well, I believe that we should have been frank towards ourselves and say that if the current legislative definitions are not possible to apply without court practices, why do we need this definition? I think that those two institutions, such as piecing of corporate veil and the structure of affiliated persons, include two important academic problems. Well, how to incorporate them into our civil legislation. And the first challenge that was first pronounced by Mr. Chorbash said that these two notions are already incorporated into the practice, but they cause the death of another legal notion, a legal person. So all these structures, such as facade subjects, through the affiliated persons and through the piecing of corporate veil, will just demolish the notion of a legal entity. I suggest the following. If we want to avoid the destruction of a legal entity notion, so for affiliated persons, for the piercing of corporate veil, we should first have either the legislative limits or the limits that stem from the legal practice. Today we cannot use the notion affiliation beyond the limits permitted by the law. Let's take any contract. Definitely, you will not put the responsibility for the supply contract on my affiliated person, because it's legally impossible. That's why I also think that the perceiving of the corporate veil should also be limited. Today I see two possible limitations to this concept. First, in cases where the liability is on somebody else. For example, the liability of the parent company for the bankruptcy of their affiliated persons or their daughter companies. And the second case, the second option that may require a more detailed consideration. I'm speaking about bans and prohibitions. We are in St. Petersburg. The land code says that land plots in the border areas cannot be purchased by foreign residents. It let's say, no problem for Russian companies. But if a shareholder is 100% foreign resident and nothing is concealed, it's clear and obvious. So what shall we do in this case? Remove the bans or keep them? I was always been taught that norms of civil law that limit civil rights should not be interpreted inclusively. I understand that when we incorporate these two notions into the civil law, we should take into account the cases when perceiving of the corporate veil is justified and is proper. Today, when we don't have these definitions and our courts are forced to interpret the law at their own discretion. But still there is a common sense, even if it's not fixed on paper, but there must be a common understanding in which cases the piecing of the corporate veil is allowed. I don't object to the control agreements. I believe that these are proper and valid documents. But what frightens me is the concepts that are included into the notion of the control agreement in our law. Well, the hidden idea is that these corporate, these control agreements will never be disclosed to anybody, that they will be top secret documents. Well, if we go the other way, let's say the disclosure of this control agreement will offer some preferences, such as, let's say, tax preferences or any other options, then in this case it would be better. Well, we as judges tend to see the reality from a negative side. Yeah. And we have discussed at another panel at this forum that if each member of our economic life behave properly, we would need not any courts. If everybody follows the rules of the game, why judges are for? But we see that people do like to conceal and to hide information. Yeah, I just remember one case when the question, who is your beneficiary, was answered, a foreign investor. But who in particular? A foreign investor. Well, that's all I wanted to say at this forum, and I'm sorry that I have to leave this interesting discussion. Thank you very much. I think that we will still go on discussing this topic. I would agree that the example that was given with the state border and the prohibition to sell lands to foreigners also applies to agricultural land. So if it's the Russian subsidiaries, it's fully in line with the civil legislation. But we also have a criminal law, and the criminal law may have different viewpoints on this topic. The last case, the Prada, who said that according to the Russian law, the shares could be purchased only by the Russian shareholder, and there was another foreign shareholder, then this law was breached. I want to see some homogeneous approach, some common interpretation of different laws. Well, as for the affiliation, I don't want to abuse your time and your interest. Do you have any questions to our speakers? Do you have any comments? Do you have? But please do introduce yourself. Alena Kucher, Moscow State University. Thank you very much for your very interesting presentations. I would like to continue this speech made by Alexandra Makovskaya and to reaffirm once again the need to have better definitions. Even the name of our panel says the problem of affiliation, but affiliation for different legal acts and for different legal systems may mean different concept. Please correct me if I'm wrong. In German law, it's not the affiliated persons but related companies. Sorry for my bad German. So let's define the notions first. So I think that the broad definition, affiliation, is correct. It's some kind of relations between the companies. So the objective, the goal, why do we are so keen about this relation? As Alexandra Makovskaya said, we may have five objectives, let's say. So for tax purposes, but the definition for tax purposes is different. It's related companies. Second, if we speak about the stock market and the manipulation on the stock market, the understanding of affiliation will be broader. The third one is, let's say, legislative or the structural. Shall we interpret the group of companies as one body or related or not related? And the last two purposes are more pertaining to our discussions. First is avoid the bypassing of legislation, the loopholes of the legislation, and finally is to define liabilities and control. For this purpose, we have Articles 5 that defines parent companies and daughter companies. I believe that we should rather use this article instead of using a broad understanding of affiliation. And finally, our Article 105 is very close to the German definition. So instead of incorporating the notion of affiliated persons into our civil code, we should rather extend the legal practice. But control is not for the control as such. Control is not the aim. But what are the legal implications of this control? And that's we should discuss. Most probably we shall never be able to give a universal definition of affiliation in our civil code. We should rather use a specialized sectoral approach, or should put the control and liability into a cornerstone. Can you be brief, please? I am Elena Trusova. I'm a partner in Goldsblatt BLP company. Just to comment the previous remark and statement of Alexandra Makovskaya. Alexandra said that we have a conflict on the piecing of the corporate whale. It's the concept of a legal entity. Sometimes we have to put aside this autonomy of a legal entity to disclose the structure of relations. He said that it's impossible to regulate everything with legal terminology, and we have to give some freedom to the judgment of courts. In fact, it happens. It does. We do see recently some cases where judges already put some first criteria for the piecing of the veil. I'm speaking about Parex Bank and Kirov plant. In Parex Bank, the judgment said that if formally these are two independent legal entities, but de facto, for business purposes, they can be viewed as a single economic unit. They should be regarded as a single economic unit. And in this case, the court judgment fixed two cases. One, the corporate veil can be pieced. First is to avoid the liability, and the second case is the priority of business or the economic purpose. In the cases of the Kirov plant and other cases that considered the role of the controlling body, these criteria are being detailed and developed. And as the chairman of our High Court of Arbitration, Mr. Ivanov, said, we should expect that in the near future, in the coming years, a piecing of the corporate veil will be seen more and more often, even without any formal criteria or any formal definitions. Thank you, Lena. And as Alexandra said, that we can really destroy the individuality and the institute of corporate liability. Maria, what was your question? Maria Abramova, Gazprom Neft Group. Just to draw your attention to one of the statements that was made today. We started to speak about the existence of the institutions such as parent and daughter company. But I would like to speak more about the economic control. The economic control is not included into the notion of parent and daughter companies, but we see it on the everyday basis. Let's say companies that are legally not affiliated, but from the economic point of view, one controls the other. It's very common to the German case. So, I think that it's good both from the accounting point of view, because we are now trying to adopt IFRS in Russia, and if we speak about the consolidated reporting, we should also disclose the information about economic control. So we should take this into account, because let's say de jure, the companies may not be linked, may not be related, but economically or de facto they may control each other through a range of third persons. Thank you, Maria. That's really true. Ulrich, do you want to say something?
The first one to the notion of economic control. Of course, there is the concept of economic control as well in Germany, but however, it must be somehow linked to a kind of control over shares. Just the fact that one company is the supplier of the other one, or is the major customer and basically takes all products, is not sufficient from a German standard. If the bank is giving all the financing to one single enterprise, that's not sufficient to make it dependent on it. There must be additional circumstances. Generally, it must be corporate law, it may be through third parties, and it depends, and that's what you were addressing, very much on the purpose of the individual act. We were talking here about piercing the corporate veil because of liability towards third parties. In other circumstances, tax, for example, the concept of an enterprise being affiliated or being closed in Germany is defined much more broadly. Foreign Trade Act under German law, when we want to check out who is actually controlling the company, there the concept is very broad again. But under these kind of liability issues, our concept is more narrow. We are checking who is controlling the votes, who is owning the shares. It might be through third parties, it might be through agreements, but it must be somebody who's controlling it. Just economic control by supplier concepts or lender concepts, that's not sufficient.
Спасибо, Ульрих. Да, безусловно, я думаю, мы пришли к общему.
Well, thank you, Ulrich. I think that we all understand and we all agree on affiliation is meaningless as such. It's meaningful when it's put together with the control and liability issues. I saw some other raised hands. I would like to extend the scope of our discussion. My name is Roman Khadikin. Alena mentioned 5 goals or 5 objectives when the notion of affiliation can be useful. I would like to speak about my competence, such as international arbitration. Well, I can also know the notes, let's say, the rejection of arbitrators. When an arbitrator can be related to the affiliated party. And let's say the test which is used, such as independence and independent and impartial. Well, in British law, the notion independence is not used because the market is so small that it's impossible to find a person who has never ever been in links with others. So impartiality is the key requirement. And another thing which is quite common today is the application of the arbitration agreement to the parties non-signatory of this agreement. And there are countries who actively use this principle alter ego concept, Stopely concept, the concept of the group of companies, the concept of agency agreement, but the use of this term is not very successful because in the cases that I have in mind, the arbitrators in all cases agreed that the parent company participated in negotiations, knew about this agreement, and is a party to this agreement. One of the well-known cases was related to Orange Group Gazprom and to Gazprom as the controlling shareholder, and while only Orange Group Gazprom signed the particular agreement.
Законодательству интересная тоже проблема, которая возникла недавно в деле в английском Peterson Farm. Это вопрос возмещения убытков. Потому что что произошло в том деле? Сторона купила товар, но купила она его не для себя.
A party there bought a commodity, so this was some kind of roosters for breeding. They bought him for subsidiary companies. So these roosters proved sick, and there was a damage inflicted, but the damage was inflicted not to the party to the agreement, but to the subsidiary. So, in other words, if we can damages be claimed by a party to an agreement, because damages are termed as a kind of a harm that was inflicted on to the party of the agreement. So can we speak of the damages in that situation? The arbiters said yes, they claimed the damages, but the British court termed it not as damages to the party of the agreement and just rejected this claim. So it was also a case in Russia, but I didn't see a reasonable resolution. I think we'll have more and increasingly more questions here. So the question about the subsidiary damage, can the person, if he is a shareholder, of course he had some kind of losses, because he will not get enough income. So, but as Markovska said, so we cannot extend our interpretation of the civil law, otherwise we will drift into the German and Anglo-Saxon law, but which is a dangerous trend, because it will give rise to judicial incompetence, just not just ill thought, but still. Any other questions? My name is Elena Kozina. I'm a barrister, but I represent the Moscow Law Academy here at this forum. My personal interest, but before I speak about it, I will make a comment. We find a lot a situation when they just stock companies appear as organizational entities in the trade and civil relationships. Our arbitration practice and the controlling bodies do not recognize as affiliated persons such stock companies, and they do not use the affiliated persons as a term, and do not use these transactions with interest notion. So just 2 years ago, the situation was different when the affiliated person, Moscow was recognized to be an affiliated person, and then just the Federal Service of the financial markets and others changed this practice. And in December 2011, the arbitration court ruled that the state pursues public interests, and it is not expedient to recognize it as an affiliated person in the stock companies that it sets up. So my question is the following. I don't know whether German has an extensive practice of setting up joint stock companies with the state participating, but the question is, are the institutions that you spoke about in the presentation applicable, and is there any notion of a dependent or affiliated person in German law applicable? It can be not a state, but any public civil institution or entity instead. So is there any practice, and how it is worked through?
The court decisions on these issues in the 60s and the 70s, and in Germany it's in principle accepted that the state can be a controlling entity. And hence, different companies controlled by the states can thereby result in being related entities. This problem has vanished to some extent because we have privatized a lot. But in general, this was accepted, but I know this is to some extent an exception even in Western Europe. France, for example, I think has a different concept, which is somehow a little bit surprising for us, on transactions where one ministry in France does it this way and the other one does it that way. and they are independent of each other officially, whereas in Germany the company controlled by the state, regardless of who in the state, is an affiliated entity. No, in Germany the concept is accepted that the state can control entities and has to accept these rules as well.
А государство, суд может снять корпоративную власть государства?
Can the state just the court rule to pierce the veil from?
It could. But the taxpayer would be. But as I said, the problem has not disappeared, but is much less relevant because we have much less state-controlled companies now than we had 20, 30 years ago.
Okay, but still there are good chances to go after the Germany if something goes wrong. Сейчас разрешите мне спикеру еще дать слово, затем я вам дам возможность выступить. Sarah.
Sarah, yeah.
Just to say, we were in a very similar situation in the UK. We have very few state-controlled companies anymore, but in theory, as you say, the state could control a company, and if it were a state-operated company, and the state would be an entity in its own right, that you could therefore, in the event that it had been in those very limited circumstances, it met the needs to pierce the veil, then yes, I guess in theory that would be true in the UK as well.
Absolutely. As soon as the state matches the criteria, like fraud,
Sure.
and the others.
Exactly. A very limited set of circumstances, but in theory, yes.
Да, пожалуйста,
Thank you.
представьтесь.
I have one observation on English law, but it's probably applicable to everybody on this panel.
Вы не могли представиться?
It is that English law has no
Can you introduce yourself so we know who's...
Apologies. My name is
who's
Reece
entertaining?
Thomas from the law firm Jones Day.
Okay.
I'm based in the London office.
Thank you.
My observation is that English law has no business in applying to the relations between a foreign company and its shareholders. And in VTB that point wasn't taken, but the general principle in English law would be that the English courts would look at the lex incorporatianis and look at the applicable law between the local law of where the company is incorporated. And it seems to me that had that applied in VTB and some other cases, some of these issues would not have arisen. And I guess that...
Thank you. Еще есть какие-то вопросы или желание обменяться мнениями?
Are there any other questions or comments or exchanges? Because we are doing very good in terms of the timing, but however we can have some more minutes for the discussion if there are more questions coming up. Andrei Shpala from South Capital. So my question is to Mr. Leck, because it is quite obvious that with trust, so delegated property. So the concept was an alien to the German laws. So can it be recognized as de facto control in such a situation?
I didn't understand it.
I may ask in English.
Давайте я дам вопрос по-английски. По английскому.
Yeah. Actually, we have gone, during the last 30 years, our courts have gone through various concepts on how you establish the liability when you have de facto control, in particular in the case of the GmbH. There were attempts to apply the rules for stock corporations in the same way. There were attempts to have a different concept of fiduciary duties. What the courts now ended up with to establish a liability is basically tort law, and there the very general provision that you are liable if you are intentionally doing harm to somebody else. And if a shareholder really abuses the form, the legal form, he always has in his mind, or he's doing that basically in order to harm other shareholders or creditors. And that's how we solve it nowadays. It's a purely tort law-driven concept.
Thank you, Ulrich. На этом я хотел поблагодарить всех участников, прежде всего наших спикеров, Майкла.
I would like, first of all, thank you to thank our speakers.
Discussions. And спасибо всем, кто выступил в прениях. Я приношу.
Thank you all very much for those who asked questions and shared their comments. And I wish you just to have fun at this wonderful forum. So thank you very much and goodbye.